And today I'd like to discuss what goes into registering a trademark for a client and what are the things that you should consider as part of that process. Law rights and trademarks. So just by using a trademark, a business obtains certain rights in it. The first to use it on a specific type of goods, then has rights to that mark in a specific geographic area. So it's first in time in a certain area. This gives you a state law remedy for it. So if you're the first to use a mark on a product in San Diego and you advertise throughout San Diego County and somebody then tries to use a similar mark on a similar product in San Diego, then you would have the right to enjoin them from using it under state law. You're allowed to use the TM symbol, the trademark symbol, or the SM symbol for a service mark with these common law rights. If you register, which we'll talk about next, with the USPTO, then you have even greater rights and you can actually sue within the federal court. So a U.S. registration is with the United States Patent and Trademark Office. It covers the entire United States as opposed to just a small geographic area where you're actually using it. So with the common law rights, I said if you used it in San Diego, then you would have rights in San Diego. If you then find out that somebody is using it in Los Angeles, even if they started using it 2 years after you, something that's similar to your mark for a similar product, then you would have the right you wouldn't have the right to shut them down necessarily as long as your advertising areas didn't overlap. Los Angeles is close to San Diego, but it's even more obvious if it was somebody in Prescott, Arizona. Then you might not have the right to stop them from using it. However, if you file a federal registration, then you get nationwide priority from the date that you file your application. So if you filed June 1st of this year, and then you find out that someone in Prescott, Arizona started using it on June 2nd, you would be allowed to shut them down and stop them from using it because you now have nationwide rights. It also allows you to use the registration symbol, which is the R with the circle around it. You can only use this if you actually have a registered trademark. You can sue in federal court, and you can get protection in the customs office. You can actually file a notice with the customs office and they will then stop import of counterfeit goods. For a lot of small businesses this may not matter, but certainly for people who are importing manufactured goods like Nike, products like that, it's a very important protection. You can also register intent to use. With common law, you don't have protections until you actually have a use date when you started using the trademark on your products and making sales with it. With a federal registration, if you file intent to use, then what you have is basically file an application saying, I'm planning to use this trademark within the next 2 years or 3 years, and I want to go ahead and lock down my protection for it. What will happen is they'll go ahead and send it through the registration process, which we'll talk about in a moment. And at the end of it, they'll give you a notice of allowance saying that you have the right to use this trademark. Once you've proved to the USPTO that you've actually started using it in commerce, then the registration will issue, and your constructive use date for that registration will date back to the date you filed your application. So even though you don't start using it until 2013, if you filed in 2011, 2011 will be your use date for all the future potential infringers. So there's actually 2 registers with the USPTO. There's the principal register, which is what we mostly think of when we talk about registering a trademark, but there's also the supplemental register. The supplemental register is a place where something that is capable of potentially being a trademark someday upon showing secondary meaning can basically sit and create constructive notice while it's developing that secondary meaning. So if you get a rejection from the USPTO that a certain mark can't be registered on the principal register because it's descriptive, they will allow you to bump it to the supplemental register instead. And then that gives you the time to build it up, and eventually you can try to transfer it to the principal register. The principal register definitely gives you more rights. It's prima facie evidence that the mark is valid and that you have the ownership to it and the exclusive right to use it. It's proof that it has in fact acquired secondary meaning if it's a descriptive mark. It gives you constructive notice on your claim of ownership, which means somebody who tries to use the mark afterwards, you can point to that and say, hey, you had constructive notice, so it wasn't good faith to start using the similar confusing mark. And it also, it can become incontestable after 5 years if you file the appropriate paperwork with the USPTO. Incontestable isn't quite as incontestable as it means, but it basically says that people can't cancel your mark on certain grounds anymore. There are certain grounds that are preserved. It's almost like a jurisdictional argument. If there was never really the right to register the trademark in the first place, it may still be canceled on those grounds, but there's a lot of ways that people can't fight it. And also the principal register allows you to file that paperwork with the customs office to prevent them from import of black market goods. But with the supplemental register, it can still help you do things like get foreign trademarks in other countries. It does still allow you to use the registration symbol. It does allow you to sue in federal court, and it doesn't actually state that you don't have secondary meaning. It just means that you haven't established it to the USPTO's standpoint. So you can potentially still sue infringers and claim that you have secondary meaning in federal court. I would like to point out a lot of clients will come in saying, I have a trademark, because they filed a fictitious business name statement. This is also a state law type of protection, but it is not a trademark. Fictitious business name is something that allows a person to file a statement with the county saying that they are using a name that is not their own for their business. So both a corporation and a person could file this. And basically, if your name was John Smith, and you had a plumbing company called Speedy Plumbers, then you would file a fictitious business name for your business with the county. It does give you certain trademark-like protections, but it is not a trademark in and of itself. So if you file a fictitious business name and you're the first one to file a fictitious business name for that business, then you have a presumptive right to the exclusive use of that business name. But again, it's not for a product or a service, it's for a business name. And it does not give you the same level of rights that you would get from a trademark registration. It only allows you to get an injunction. This is at least true in California. It allows you to get an injunction against people who try to use the business name in the county where you filed it.